All eyes on Washington, D.C. last week to see what the grand jury was going to do. And as Trump's lawyers met with special counsel Jack Smith as the indictment against Donald Trump for the insurrection and other criminal conduct relating to the 2020 election is imminent, a bombshell dropped. Special counsel Jack Smith brought a superseding indictment against Donald Trump, his co-defendant Waltine Nauta, and a new co-defendant, Carlos de Oliveira, the head of maintenance at Mar-a-Lago, regarding the theft of the thousands of government records. The new charges relate to a conspiracy to destroy surveillance footage at Mar-a-Lago to try to cover up the fact that Donald Trump was keeping these classified and other national defense information. We will break down this superseding indictment. And as I just mentioned, an indictment against Donald Trump for criminal conduct relating to the 2020 election is imminent. It could have happened as early as last week, that same time that we talked about the superseding indictment breaking. That's when we thought the other indictment is breaking. When I say imminent, I mean, and I want to get your take, Popok, in a little bit. Any day now, I think we're going to have a breaking news story on the MeidasTouch network that Donald Trump has been charged with hundreds of criminal counts relating to his conduct in 2020. Let's discuss the meeting that Trump's lawyers had with special counsel Jack Smith. Let's talk about some of the remaining pieces of key evidence that special counsel Jack Smith got as he concluded the criminal investigation, like former top DOJ Trump official testimony about an unreported February 2020 meeting, and other key testimony. We will break that all down. Also, Rudy Giuliani, Donald Trump's lawyer, embroiled in the 2020 election interference case by Trump, also just filed a declaration in federal court in Washington, D.C. in the defamation case brought against him by Georgia election workers Ruby Freeman and Shay Moss. In this declaration, Rudy Giuliani admits to liability. He admits that he defamed Ruby Freeman and Shay Moss. It breaks down each and every element of a defamation case in this declaration. So why did Rudy Giuliani file this declaration? And why is he now claiming that he didn't say what he said in the declaration? Well, that last question is probably obvious because Giuliani's a complete and total liar. But stick around and we'll break down the former for you and its implications. And finally, in Trump frivolous and vexatious litigation news, I guess that's every single week at this point, Donald Trump had a second-year lawyer or a year-and-a-half lawyer file a motion to reopen the case in the Southern District of Florida, where a federal judge had already sanctioned Donald Trump and Alina Habba close to $1 million. Y'all remember this case? That's this purported RICO case that Trump filed against Hillary Clinton and 30 other individuals, alleging that they all framed him for the investigation into his connections with Russia. Remember how the federal judge said that the complaint Donald Trump filed was basically like cut and paste ranting and ravings of a madman, said every single claim was frivolous, and even suggested that Alina Habba should be disciplined by the state bar for filing such a vexatious case. Yes, that case. So Trump had this second-year lawyer try to reopen the case, file a motion to reopen the case, arguing that the Durham Report, which essentially made no recommendations at all. John Durham is the special counsel appointed by Bill Barr, who went 0 for 2 in the trials that he brought in connection with his failed investigation, that somehow that report provides new evidence to reopen the case. Oh my gosh, Popok, this second-year associate just threw away his career. And then some breaking news earlier in the day. A Trump-appointed judge in the Southern District of Florida also just dismissed Donald Trump's $475 million defamation case against CNN, where Trump said that, when CNN referred to his conduct as the big lie, that was defamation. No, says the federal judge that Trump appointed. We'll break all of this down. We've got a big legal AF today, and starting with this superseding indictment. Michael Popok, busy week.
Busy week. Photos, texts, video clips, at least 4 insiders testifying against Donald Trump in a really, really important timeline. Put it all together in a pot of jambalaya, you come out with a superseding indictment, and you and I can't wait to unpack it for our audience.
So if you've been watching Legal AF, which I think all the Legal AFers have been here, although there's some people new to Legal AF, we've been following Carlos de Oliveira, this maintenance worker, his conduct, his conversations with the grand jury. Obviously, we could only speculate what they were because of grand jury secrecy. But we've been talking about Carlos de Oliveira, right? So for the Legal AFers, that name, this head of maintenance at Mar-a-Lago, is not a shocker, right? You know, we also talked about other individuals. Like we get granular here, right, Popok? So we talk about Yusel Taveras, who is identified only by the nomenclature employee number 4 in the superseding indictment here as well. And Yusel Taveras is the head of IT. And so on the last Legal AF and the Legal AF before that, one of the things that you and I were speculating was not if there was going to be a superseding indictment. It was really who's cooperating and who isn't. And you and I really broke down that we thought ultimately Yusel Taveras, the head of IT, was the cooperating witness, and that Carlos de Oliveira was the likely target. And, you know, the only thing that I think was surprising to us is that it probably wasn't all that surprising. We were focused on, was Trump going to be indicted in Washington, D.C. for his conduct relating to the 2020 election? And when I heard that the magistrate judge in D.C., who would be responsible for the arraignment and kind of proceedings after charges are brought, had packed up for the day, I thought that I could pack up for the day. And so for a 30-minute period of the whole day from doing breaking news hits, I had to drive somewhere to pick something up. And I said, I'm good. And within about 25 minutes of the drive, I get a call from my younger brother, Brett. He's like, Did you hear? I said, what happened? He goes, they brought a superseding indictment. So now I'm in the car. I'm not near, where I would normally do the hot takes. I don't have my mic because I've left for, 20 minutes of my day. That's how much breaking news is happening.
How dare you? How dare you?
Fortunately, I found a studio nearby, after making a few phone calls. So it was a new background, and you and I were able to do the hot take on it. But break down, Popok, the superseding indictment. What are the new key allegations about the destruction of this surveillance footage, the new co-defendant here? And also, if you can flesh out too, there's that new allegation as well, or new additional information regarding when Trump was showing that classified material to the individuals in July of 2021. In the initial indictment, right, it talked about that it didn't mention specifically what he was showing them. So then Trump went out and lied and said, I was just showing him magazines and papers. But now in count 32 and in the allegation, it's clear that these were the war plans. So how big is that? Break it all down for us.
Huge. Weather changing, oxygen sucking, new indictment. There's a reason that prosecutors wait until they have all their ducks in a row to go back in front of a grand jury and ask them to do an amended or superseding indictment. And this is the reasons. These are the very good reasons. We're going to talk about Carlos de Oliveira. We're going to talk about Walt Nauta. We're going to talk about Yusel Taveras, the IT director. And I'm going to throw a new one in there, Molly Michaels, who is the longtime right-hand assistant for Donald Trump, and her involvement and her being mentioned as employee number 2, Trump employee number 2 in the indictment. I will talk about her as well. There's a number of different ways that you can explode and do an explainer about the new indictment. And you and I did it on a hot take. But one way to do it is with the timeline. And the timeline has a momentum and a power of its own. And it gives you an idea of how Jack Smith both developed the new information for the indictment, knows that he has Donald Trump by the short hairs or other anatomical parts, and is ready to go to trial on this case. And again, we're just seeing the tip of the iceberg of the weight of the evidence that will ultimately be presented, because you don't have to put everything in an indictment. And of course, Jack Smith hasn't, but what he has is mind-blowing. Let's do the timeline. And I'm going to do, there's really two timelines that are important. They intersect in one spot. But the two timelines are the ones related to the Department of Justice finding out that there are surveillance cameras at Mar-a-Lago during a June 3rd of 2022 visit, them subpoenaing them, and what Donald Trump did in a conspiracy to delete the evidence, obstruct justice after that. And then the Iranian war planning document, which, as you said, great in a hot take, Jack Smith laid a trap. And as always, Donald Trump stepped right into it about the existence of the document, because again, common theme, asymmetrical informational warfare between a prosecutor who has it all, witnesses that the defense doesn't even know about, cooperating witnesses, insiders, employees who are telling the truth for dear life to avoid indictment, not lying, as Donald Trump says, telling the truth for dear life. They have all of that arrayed against the individual like Donald Trump, who, never can tell the truth and even misleads his own lawyers. And so they're automatically at a disadvantage because they say X happened and Jack Smith has 7 or 8 different data points that says that's a lie. And then he just lets him walk into that trap. This is the reason, as you so eloquently put it, Ben, Jack Smith doesn't want to gag Donald Trump. Jack Smith wants Donald Trump to keep going on television and using those new lies and those new information against him in indictments and in courtrooms. Let's start with the timeline. January of 2022, Donald Trump, by himself and without lawyers, sends back 15 boxes to the National Archive and says, okay, that's all there is. National Archive and the Department of Justice, knowing that that's a lie from their insider information. But we do know from testimony by Molly, we believe by Molly Michael, who's the right-hand administrative assistant for Donald Trump. She's the one that when in the White House, in the Oval Office, Donald Trump would yell out, "Molly, get blank on the phone for me," right? She's like the Betty Curry for Clinton, if you will. The Rose Lincoln for Nixon or whatever. Same thing. That's Molly. And she was everywhere. She was there on Jan 6th in the Oval Office. She knew a lot of things at Mar-a-Lago. She was helping the return of the documents. She was texting with the lawyers about getting Donald Trump to pay attention and return the boxes. And she gave evidence, we believe, to Jack Smith that completely countered that which the lawyers were telling for Donald Trump were telling Jack Smith, which is our guy had no involvement at all with picking out the boxes or the files that went back to the National Archive. That's a lie. Donald Trump personally, because they were his, they're mine. I don't want others searching through them. He went through the boxes. He self-selected the 15. So he's up to his neck in that, which is great for the prosecution. They go back January of 2022. Then the Department of Justice later issues because they can't get the documents voluntarily back from this guy, they issue a subpoena. They get a subpoena issued, which is ultimately an order of a federal judge. This is before the search warrant. We're at the beginning of the summer of 2022. In May 11th to June 3rd, based on notes of Evan Corcoran, the lawyer for Donald Trump, who took 50 pages of copious notes that had been turned over to the Department of Justice, he said that he told Donald Trump, you got to return these things. You got to comply with the subpoena. Donald Trump originally did not want to comply with the subpoena and said, why do we have to? And he said, couldn't you also just make some documents disappear? This is in Evan Corcoran's notes. Evan Corcoran then made a fatal mistake, or he did it on purpose, which is he turned his back on Donald Trump for a full week in late May of 2022, and said, I'll be back next week, Mr. President, to go look through that storage room for those confidential documents. Donald Trump heard, I got a week to go hide documents from my own lawyer so he doesn't turn them over to the Department of Justice. And so starting on the 17th of May and through the 24th of May, we've got the video of Walt Nauta, moving boxes in and out of the storage room, 50, 60 at a time, bringing them to Donald Trump for his personal review and then return to the storage room. Then we've got June the 2nd, the final gasp of moving the shell game of documents by Donald Trump to keep them away from the Department of Justice, because June 3rd is going to be a meeting with Jay Bratt and his lawyer, and he knows it. So he does this last gasp, pulls 30 more boxes out of there through Walt Nauta. Evan Corcoran then goes into a room that he doesn't know has been staged for his arrival and spends 30 minutes looking at documents and comes out with 38 sealed in an envelope and gives them to Jay Bratt, the lawyer for the Department of Justice. Jay Bratt looks around with his team and sees video cameras in and around these storage areas. And soon thereafter, at the end, June 22nd of 2022, there's a new subpoena by the Department of Justice for the camera footage, which leads now to the infamous call in the new indictment, which I now have said, this is, I assure you, in the history of America, this is the longest call between an ex-president and a maintenance worker in history. It's 24 minutes long. Donald Trump to Carlos de Oliveira, his former valet, now head of maintenance. The same guy that flooded the server room with the pool at the same place. And on the 24th of June, they have a 24-minute call. We don't know the content of that call as of yet, but on the 25th, Walt Nauta returns to Mar-a-Lago, has a meeting with de Oliveira, and they start searching for the video cameras with flashlights that it's caught on video, trying to find them. Nauta makes a phone call to Matt Calamari, the COO of Trump Organization, who's responsible for security, about the video cameras. And we already know that because Matt Calamari testified to Jack Smith. And then on the 27th of June, there's now the thing that's going to hang Donald Trump. When Walt Nauta says to Carlos de Oliveira, the boss, Donald Trump, wants the server deleted for the video surveillance information, they bring in a third-party witness who's the insider cooperating, who is Tavares, who's the IT director, who feigns ignorance about how to delete a server. I assure you, the IT director knows how to delete a server. He says, I don't know how to delete a server, which is good that he didn't delete. He's cooperating with Jack Smith, and that's where a lot of the photos, text, and other information came from. With a boss telling his employees to destroy evidence is called consciousness of guilt evidence. It's the gold standard, platinum standard for a prosecutor, because nobody who's innocent does the things Donald Trump is doing, like telling his people to delete the server. Then you have the actual video, less some deleted video, turned over at the end of July to the Department of Justice, which leads them in August 8th, to execute a search warrant, because now they know that Donald Trump is not only lying to them, but he's destroying evidence, threatening to destroy evidence, and they convinced the federal judge to do that. That is, before I talk about Iran, why don't you comment on that, Ben, and then I'll take a break and talk about Iran next.
You know, as I reflect on the timeline that you gave, and I think you broke it down so eloquently and perfectly there, but what I reflect on is the legal counsel representing Yusel Tavares, representing Carlos de Oliveira, and representing Waltine Nauta. And the people who are representing them are all hired by Donald Trump. Trump's political action arms, which are all being criminally investigated by special counsel Jack Smith for money laundering, for wire fraud, for other criminal campaign finance related violations. Those are the entities that are paying for counsel for de Oliveira, Yusel Tavares, Waltine Nauta. There's such compelling information right there. And Popok, the timeline you constructed is very similar to the one that special counsel Jack Smith conducted. And the question is, well, how did Jack Smith get all this information? And it's because that's what the Department of Justice does when they work effectively. And that's what the FBI does. You know, they have cooperating witnesses who voluntarily provide statements about the timeline. And then you have subpoenaed records, cell phone records. If people aren't being cooperative, you have to issue search warrants to seize information. One of the hot takes you did, Popok, is how in connection with the Mar-a-Lago investigation, there was about 7 or 8 other search warrants. And that doesn't necessarily mean that they were search warrants on property. That could have been, I mean, the actual land itself, like Mar-a-Lago. It could be search warrants for phones. It could be search warrants for laptops. When people don't voluntarily respond to the subpoena, that's what the action special counsel Jack Smith had to take. Now, if and as well for surveillance footage, a subpoena for surveillance footage, and then a search warrant for surveillance footage if stuff isn't being turned over. And so if you were competent counsel and truly independent representing Walty Nauta and Carlos de Oliveira, you would be saying, hey, you need to have a proffer session. You need to cooperate. You need to enter a guilty plea. Or there's going to be very serious charges against you, or you're going to be charged in the first instance. Now they're going to have to enter, a guilty plea. But I've been reading a lot on this Carlos de Oliveira individual. I think he's an immigrant from Portugal, showed up here. It's one of the first jobs that he ended up getting, worked his way up to become, the head of maintenance at Mar-a-Lago. And there are quotes from his family members saying, Carlos de Oliveira is a maintenance worker and doesn't know the intricacies of the law here, doesn't know anything like that. And he's being represented by lawyers that Trump handpicked, and they're all being walked into this, this criminal conduct. Now, I think at some point, and I'll get your take on this, Popok, they're going to wake up, they're going to hire, they're going to fire those lawyers, or they're going to figure the situation out that they're in a lot of trouble. Or they're going to keep digging the hole, keep on digging the hole bigger here. But that's one of the things that I'm reflecting on as you give that timeline. But we could talk about the other portions.
Yeah. And just on that, I you and I always see eye to eye on a lot of things. De Oliveira, and I joked with you in a chat, I'm not joking, Trump likes to exploit immigrants. Poor Walty Nauta, who came here from Guam, petty officer in the Navy, and look what his entire reputation and career is laying in tatters in the history books, as will de Oliveira. These are the very fine people that Donald Trump likes to signal that he protects. De Oliveira, just to show the continued conspiracy, as soon as the search warrant was executed, the kind of holy shit moment for Donald Trump, wow, I got FBI agents pounding down the door here in August. I guess all my attempts to play cat and mouse with the Department of Justice and spoon feed them documents and not turn them all over has gone slightly awry. He then had Susan Wiles, part of his pack, reach out on a DM platform, which Jack Smith has a copy of, and say to him, hey, classic mafia speak, organized crime speak, the big guy, or whatever he said, the boss, wants to just check to make sure Carlos is loyal and let Carlos know we're going to get him a lawyer. So now Carlos, right? There's a search warrant executed. Now Carlos, the maintenance guy, has got to get a lawyer paid for by Trump. Why is that? Because Donald Trump knows what Carlos de Oliveira did or tried to do at his behest. And that's another consciousness of guilt. Now, the Iranian war documents is another TikTok timeline. But there's an overlap I said at the beginning, and that is, remember that date of January 2022, Donald Trump on his own, without keeping an inventory apparently, and without lawyers involved, sends 15 boxes back to the Department of Justice, to the National Archive. In that box was the Iranian war document that he claims he never had, never saw, wasn't talking about a real document, and he doesn't know what the Department of Justice is talking about. Hold that in your head. How do we get to the Iranian war document? It starts, as always, with Trump trying to retaliate against somebody. That somebody is General Mark Milley, the chairman then of the Joint Chiefs of Staff, who gave an interview that was published in the New Yorker magazine on the 15th of July of 2021 by Susan Glasser, entitled, "You're Gonna Have a Fucking War." This is the quote from the New Yorker magazine, Mark Milley's fight to stop Trump from striking Iran. Donald Trump didn't like that article. And so 6 days later, literally at Bedminster, at his office near a pool, He loves pools and offices. He had a group of people in his office to talk about Mark Meadows' future memoir, which has its own sweet irony all to itself, that Mark Meadows thought people were going to be reading his memoir and he wasn't going to be in jail. So during that meeting, he starts showing off. We hear the audio because we've heard the audio since the original indictment, in which, with a group of people, including Margot Marks, one of his assistants, the one that kind of looks like Melania, if you're going to look for her on Google, and a writer and an author, he starts pulling out a document and unfurling it in front of the group because you can hear it. And he says, isn't this incredible? This was highly classified. I could have declassified it when I was president. I can't do it now. But just look, it was him, meaning Mark Milley, not me. It was him about Iran. It was him, not me. Isn't this amazing? Look, it's right here. Okay. That, of course, Jack Smith already has the testimony, obviously, from the other 4 people in the room, none of which had top security clearance, of course, as the president clung to this document from the time he left the White House all the way until July of 2021 to pay back Mark Milley for the New Yorker piece. Okay, and he yells for Cokes in the middle of it. Hey, bring in some Cokes. Great. Now, Donald Trump then goes on Brett Baier in a town hall, and with Jack Smith sitting there kind of like this. For those that are not watching us on video, I'm just sitting here with a Cheshire cat smile for Jack Smith and saying, let's see what he does next. And what he did next was he denied the existence of the document. He says, I don't know what they're talking about. It was a pile of things about Iran, which, by the way, also translates to national defense information. That's an Espionage Act violation.
Popok, one of the things I want to do is I want to actually show that video of the interview with Brett Baier to show our audience how incriminating it is. And we're going to do that. But first, let's take a quick break.
As you know, I'm a trial lawyer, and when I'm not breaking down the latest legal filings of the day for you on Legal AF, I'm jumping from courthouse to meeting, and it can be exhausting and, frankly, dehydrating. That's why I started using Liquid IV. Liquid IV is the #1 powdered hydration brand in America and is now available in a sugar-free option. With 3 times the electrolytes of the leading sports drink, plus 8 vitamins and nutrients for everyday wellness, Liquid IV hydrates 2 times faster than water alone. And you can keep your daily routine exciting with 3 new flavors: white peach, green grape, and lemon lime. I love how Liquid IV makes me feel. After having Liquid IV, I feel ready to take on the day at full strength. Also, the packaging is super convenient and makes it super easy to carry with me for when I need it most. My favorite flavor is the white peach. It's robust and super satisfying, but you can't go wrong with green grape and lemon lime either. Just 1 stick of Liquid IV in 16 ounces of water hydrates you 2 times faster and more efficiently than water alone. There are no artificial sweeteners and 0 sugar, with a proprietary amino acid allulose blend for a sweet taste without the calories or raised blood glucose levels you get from sugar. And of course, it's non-GMO and free from gluten, dairy, and soy. Liquid IV believes that equitable access to clean and abundant water is the foundation of a healthier world. They partner with leading organizations to fund and foster innovative solutions that help communities protect both their water and their futures. To date, Liquid IV has donated over 39 million servings in 50-plus countries around the world. Real people, real flavor, real hydrating. Now sugar-free. Grab your Liquid IV Hydration Multiplier sugar-free in bulk nationwide at Costco, or get 20% off when you go to liquidiv.com and use code LegalAF at checkout. That's 20% off anything you order when you use promo code LegalAF at liquidiv.com. My old mattress would overheat while my partner and I were laying in it together, making for a terrible night's sleep. I'm so excited to say that this episode is brought to you by 8 Sleep. Summer is reaching its apex, and there's nothing worse than tossing, turning, or sweating in the night because of summer heat. The pod cover by 8 Sleep will keep you cool all night, all the way down to 55 degrees Fahrenheit, so you wake up fully refreshed. The pod cover by 8 Sleep fits on any bed like a fitted sheet. The pod cover will improve your sleep by automatically adjusting the temperature on each side of the bed based on your and your partner's individual needs. It can cool down and warm up and adjust based on the phases of your sleep and the environment that you're in. I love 8 Sleep because we spend almost half our lives in bed. So improving our sleep routine, habits, and overall sleep quality should be a priority for everyone. I love the temperature control and that my partner and I can set our side to each of our likings. I also love the gentle vibrating alarm each morning. I wake up feeling refreshed after a great night's sleep, allowing me to start the day off right. 8 Sleep's technology is incredible. While temperature is the biggest game changer, the pod cover has other amazing features. For example, thanks to the pod's sleep and health tracking, you can wake up to a personalized sleep report for each morning that offers insights on how certain behaviors, like late night exercise or caffeine, impact your sleep and overall health. The pod cover by 8 Sleep truly provides the ultimate sleep experience. I've never experienced sleep like this. And the pod's cooling technology has been a lifesaver this summer. Invest in the rest you deserve with the 8 Sleep pod. Go to 8sleep.com/legalaf and save $150 on the pod cover. That's the best offer you'll find, but you must visit 8sleep.com/legalaf for $150 off. Stay cool this summer with 8 Sleep. Now shipping within the US, Canada, the UK, select countries in the EU, and Australia.
We are back live on Legal AF. A special shout out to our sponsors there. I love our sponsors. And by the way, that 8 Sleep has like revolutionized my sleep. Like I truly mean that. I talk about 8 Sleep all the time. It tracks my sleeping patterns and it kind of wakes you up right after the REM sleep. So it wakes you up at the perfect time anyway. It's great. I could go on and on and on and on. Okay. But where we last left off, Popok, you were talking about that meeting that that took place in July of 2021 that's mentioned in the indictment, where Donald Trump's holding up these classified documents, which we know are war plans regarding Iran. And Donald Trump is saying, doesn't this make me better than chairman of the Joint Chiefs of Staff, Mark Milley? Like, aren't I the greatest? Doesn't this make me the winner? That's actually what he is saying. But in the original indictment, what it doesn't specifically say is that those documents are one of the counts that Donald Trump is being charged with. And it doesn't specifically state what those documents are. So Donald Trump, as I mentioned in one of the hot takes, like walked right into the trap because clearly you would know if you were represented by competent white collar criminal defense, they would say, this is why you have the right to remain silent. Assume that they have that document and that record. Do not do this. And this is exactly what Donald Trump said when he went on Brett Baer. We're going to play the video right now.
Before you run it. The Department of Justice, after hearing that tape, before Donald Trump's denial, subpoenaed Donald Trump to turn over that document, knowing that they had the document already.
That's so good. That's such a good...
And wanting to see what this is. Jack Smith going, I want to do a special level of torment now on Donald Trump and his lawyers. I'm going to ask him for the document and a subpoena and see what he says. He's going to say no such document, and then we have the interview.
That's so you are so right. Jack Smith had the document the whole time, and then separately sent a subpoena for the document just to screw with Trump and to see how Trump would respond. That's so good. So I never even thought about it like that. You're so right. Here, play this clip of Trump's interview with Brett Baer shortly after the original indictment was brought. Play the clip.
I don't want to dwell on it, but according to the indictment, you were here at Bedminster on July 21st, 2021, after you're no longer president, and you were recorded saying that you had a document detailing a plan of attack on another country that was prepared by the U.S. military for you when you were president, the Iran attack plan. You remember that?
Ready?
You were recorded.
It wasn't a document.
Okay.
I had lots of paper. I had copies of newspaper articles. I had copies of magazines.
I know. This is specifically a quote. You're quoted on the recording saying the document was secret, adding that you could have declassified it while you were president, but, quote, now I can't. You know this is still secret, highly confidential. And the indictment cites the recording and the testimony from people in the room saying you showed it to people there that day. So you say on this on tape,
it says just the opposite,
that you can't declassify it. So why have it?
When I said that I couldn't declassify it now, that's because I wasn't president. I never made any bones about that. When I'm not president, I can't declassify.
And that's what you said. You didn't declassify it.
I said no. I said I couldn't.
But that
wasn't a document, Brett. There was no document. That was a massive amount of papers and everything else talking about Iran and other things. And it may have been held up or may not, but that was not a document. I didn't have a document per se. There was nothing to declassify. These were newspaper stories, magazine stories, and articles.
I'm just saying what the indictment says.
Well,
the recording
people,
and the people in the room who testified.
These people are very dishonest people. They're thugs. They're thugs. If you look at what they've done to other people, what they've done to, and overturned in the U.S. Supreme Court, these are thugs.
The suggestion was that you wanted this as evidence that the military, the chairman of the Joint Chiefs, General Milley, had preemptively sent you plans for a possible attack on Iran, and that you didn't order that to happen. That's the suggestion.
I never ordered it to happen, no.
But
no.
That's why you wanted the document.
I don't think I've ever seen a document from Milley. Milley, frankly, was incompetent. The last one I'd want to attack with as my leader would be Milley. That I can tell you.
All right,
and I
last
think
thing
you know
on
that.
this.
But notice there when he's actually hit with the facts, the thing that he does, which he always does, they're thugs, incompetent. You know, he just goes right there, and they're thugs, they're liars, they're horrible people. These are disgusting people. But Popok, you have that interview, and then take us through now the superseding indictment line and count 32.
So in the actual, just to unpack the interview for just 1 second, great job, Brett Barrett, by the way. He actually says, in a moment of Freudian slip, in his own way, telling the truth for a moment in Washington, he said, I may have held it up. I may not have. Well, how do you hold up a document or not if it doesn't exist? So he got tongue-tied, because when you're not telling the truth, it's hard to put a grammatically proper sentence together. And we're watching Donald Trump there. I don't know if you could see the flop sweat, but I'm sure there was flop sweat, because nothing he was saying was just filled with non sequiturs and didn't make any sense. I had the right to declassify, right? But your point is you hadn't, and you were showing it to other people. Right, I had the right. I mean, he's literally not following the continuity of this thought at all. The reason that Jack Smith wanted to nail down Donald Trump and issue a subpoena is because he had already located Jack Smith's team in the box of 15 boxes sent to the National Archive by Trump alone, without apparently an inventory. I'll tell you why that's important. That means that Trump's lawyers, whoever they are at the particular moment, Parlatore, Corcoran, Bob, anybody else, they don't know what he sent back. So they can't. It's hard to fight the government when they have the information and you don't know what your own client sent back. That's where Donald Trump left his lawyers. Not only does he keep them in the dark, take documents away from them, talk to them about conspiracies to commit fraud, but he also doesn't give them the information they need to do their job. And so Jack Smith had already obviously shown the document that they believed to be the Iranian war document to Margot Marks and to the others in the room to confirm, is this it? Under penalty of perjury? And they said, yes, it is, Mr. Smith. But they wanted to make sure there wasn't another document. So they said, okay, maybe he's got another document. Give us your document. Nope, there's no document. Okay, well then we know then the one we showed the witnesses and we've corroborated is actually the war document. And so we then have the new set of allegations. I don't know if you want to put them up on the screen, Ben. You have them in front of you?
Yeah, I mean the new allegations. Yeah. It's count 32. It's on pay, and then so that's really the main one, and it just adds that one kind of piece of it that they've got that they have the record and it has a war plan. It's top secret, no foreign, meaning no foreign intelligence.
Exactly. It had the hooks, as you said earlier, Ben. The hooks for this count was already embedded, like a ticking time bomb against Trump in the earlier indictment. But now, after they ran through this last cycle, including watching him hang himself on television, they then nailed him in the indictment. And the timing, back to timing again, the timing of the superseding indictment is so exquisite for Jack Smith, who, again, I think enjoys his job. Okay? I mean, let's just leave it at that. I mean, he enjoys his job. And so in the morning, when he's busy having the perfunctory audience with Todd Blanche and the new lawyer John Lauro from Tampa, in his offices in Washington, on the moment before what we thought was going to be the indictment later that day, he said, "Okay, great, I had a meeting. Okay, thank you. What's your presentation? Yeah, okay, thank you. We'll get back to you on that one." He already knew that he had already given the green light to have the superseding indictment shot down in Miami, that had been returned already. So that filing of that indictment, he did not, I'm sure, tell the lawyers for Donald Trump in that morning meeting, hey, by the way, you got another fish on the Barbie there. We're superseding the indictment with new evidence. But that is what you have to be prepared for. And Donald Trump is not, because he's outmatched and outwitted by Jack Smith and his team, because the evidence is overwhelming. As Ty Cobb, one of his lawyers, once said just recently, Ty Cobb said the original indictment was pressure tested to last for 100 years. The new indictment will last until an antiquity. That's the former lawyer for Donald Trump, Ty Cobb. So not only do you have, it's hard enough, and you and I have been on the defense side in cases involving the federal government. I will tell you, it is hard enough to box with them when you're basically outmatched in terms of information and asymmetry. But when your client is lying to you, and your client is misleading you, and your client is not telling you about documents that exist or things that he returned, you're making it almost really impossible for any defense to be mounted for you.
You know, let's talk about that meeting that Donald Trump had kind of right before the superseding indictment hits. You have Trump's now two lead lawyers. You got Todd Blanche and John Lauro. Lauro is a new lawyer on the team who apparently is only dealing with the issues related to Donald Trump trying to overthrow our democracy. But we'll see there. You know, the interesting thing is that Trump actually has a very competent lawyer, you know, and that may upset people to hear that, you know, when I'm calling one of Trump's lawyers competent, but it's the reality. The last remaining competent lawyer on Trump's team is this Christopher Kise, who is the former Solicitor General in Florida. Christopher Kise was given about a $3 million retainer and brought in because of his qualifications, but ultimately, Chris Kise doesn't look like he fits the part. He's not out of central casting the way John Lauro is. And so Trump sidelined Christopher Kise. Kise, back in September of 2022, wanted to arrange basically a settlement between Trump and Merrick Garland and the DOJ, where Trump would admit to taking the documents, apologize, say it was a misunderstanding, and that was before special counsel Jack Smith was appointed. If Christopher Kise's advice was followed and Trump didn't further entrench himself in more criminal conduct and obstruction, there could be a very different situation regarding the criminal case against Donald Trump regarding the theft of these records and the willful retention of national defense information. But now he's got these blowhards. You had John Lauro go on the Fox and all the right-wing media and do the thing that they always do with the accordion hands, where they just talk about, you know, they gaslight the American people. These were the individuals who met with special counsel Jack Smith there. And at the same time, that meeting took place where special counsel Jack Smith said, get ready, an indictment is imminent regarding the case against Donald Trump for trying to overthrow our democracy, January 6th insurrection, all the related crimes there. Additional information was starting to get reported about some other key evidence that special counsel Jack Smith had developed. A meeting that took place in February of 2020 between Donald Trump and some of his top officials, where they were praising the efforts by the Department of Homeland Security and some of the related divisions within the Department of Homeland Security for protecting election integrity and for having the safest and most secure elections ever. And Trump wanted to hold a whole press conference where he wanted to take the credit for all of the work that they did to make this the safest and most secure election in history. And then a month later, he basically, you know, realizes, whoa, if I lose this thing, I need to blame them. So I'm not going to do that. But that meeting's important because it goes to intent. And then also a meeting with a former top DOJ official. So Popok, break down these other pieces of evidence that we are now learning about regarding the case that we expect an indictment to hit next week regarding Trump's conduct in overthrowing our democracy.
Yeah, and they all go, as you said, Ben, to continuing to build the case for that element of a crime that every prosecutor It's what keeps them up at night, proving willfulness, criminal intent, what we call mens rea. And you have to do it through circumstantial evidence because nobody ever admits on tape, I did it. And certainly Donald Trump has come close to acknowledging that he knew that he lost the election and actually said it out loud to at least Alyssa Farah, who was his communication director at the time. But that was the last time he ever said it. And then after that, it was fraud, 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 fraud at every turn, including recently. Like, I can't wait to get into a witness stand. This is what he tells his supporters at rallies. I can't wait to take the stand and bring all the, and prove wrong all the people that said there wasn't fraud in the election. Can't wait. I got news for everybody. Whether you're going to vote for him or not, he is never taking the stand in any of these cases at all. So that will never happen. But the new evidence that goes to mens rea and criminal intent, as they try to answer the question, where did this guy jump the tracks in terms of claiming fraud? It starts with new testimony about a February 2020 Oval Office meeting, which again, similar to the Mark Milley New Yorker article, retaliatory meeting on the Iranian war document, something lit the fuse. And the thing that lit the fuse for the meeting to talk about election security, in which Donald Trump crowed about, in February of 2020, this is going to be the most secure election ever in history. And I want the FBI and the Homeland Security Director to go to the airwaves and give everybody assurances that, unlike in the Hillary days, this is going to be really safe and secure. And then a month later, he's off campaigning against the election in advance, saying it's going to be filled with fraud. Where did that happen? And of course, they can use the evidence of that particular meeting, who obviously was attended. If I had to put together a list of who was there, I would suspect it was Chris Wray, the FBI director, Ken Cuccinelli, the acting director of Homeland Security, Chris Krebs, the cybersecurity head for all things election, that Trump eventually fired because he said exactly that the election was fair and integrity was protected, and Mark Meadows. So you got that group, of which a number of them have already gone in and testified to the grand jury or are cooperating with Jack Smith. And but that was in response to a other employee or aide to Donald Trump who had given an interview in which he gave credence to the Russia interference that led to Hillary Clinton's not getting elected. He didn't like that. And so the counter to that was this February 2020 Oval Office meeting, which obviously we have so much detail about it because the other participants in it have all given testimony or are cooperating with Jack Smith. That goes to criminal mind. You said it once was fair. What happened? If you really want to go back, talk about timelines for this running theme of our Legal AF today, go back to 2017 and 2018. That's where Roger Stone invented the concept of stop the steal. They were using stop the steal before Trump beat Hillary Clinton. So I guess they stopped the steal because he won. But they've been saying stop the steal, and they were going to use that in any place where the Republican candidate, in this case Trump, was behind in the polls, as to try to cast doubt on the election and the integrity of the election.
Hey, they used it in the Republican primary.
Stop the steal. I'm like, what's
they
steal?
used it in the people forget they used it in the 2016 primary when Trump would not win a state. In some of the earlier states in the primary, that's what they said. They said it was rigged, and that's what they continued to say.
And Roger Stone is the mastermind. He's the evil genius behind Stop the Steal. You can look it up. He learned his tricks from the best, Tricky Dick Nixon, Richard Nixon. He worked for him, and this is that genealogical line that we can trace from one fraudster president all the way to another one in Donald Trump, and with people along the way that helped. Then we have the other meeting that Richard Donahue, who you and I really shouldn't be talking about in history. I defy you to tell me who the acting deputy attorney general was in any other administration, but we know who they are here because as Donald Trump doesn't get the right answers from his attorney general, as he continues to try to interfere with the election results and cling to power, he fires them. So Bill Barr goes, and even though there's like days left on the clock for the administration, he puts in acting Attorney General Jeff Rosen. And so everybody moves up a notch, and Richard Donahue becomes the acting Deputy Attorney General for like the waning days, mid-December till Jan 7 at midnight. And that's when things are really going haywire, because now Donald Trump realizes all of his efforts to date have failed and he's going to have to leave office in 20 days or whatever it is. So he has a meeting that Richard Donahue takes notes about. And we actually have a picture of the notes because they've been revealed. And he takes notes. There they are. There's one page of Richard Donahue's notes. He takes notes about a meeting he had with his boss, Attorney General Jeff Rosen, and Donald Trump, in which Donald Trump said to Jeff Rosen, just do me a favor, have the Department of Justice just declare that there's some sort of fraud that they're investigating in the election, and me and the Republicans in the House will take it from there. And Richard Rosen told him, and I'm paraphrasing, no effing way are you going to weaponize the Department of Justice and use us that way. That is not happening. And Richard Donahue, as a good scribe, is writing this all down in his notes and testified. We know that Richard Donahue testified this way because he was one of the key witnesses that we got to see in the Jan 6 committee, not just in giving interviews with them, but he was actually live and testified live with Adam Kinzinger in the Jan 6 committee, in which one of my favorite moments is when he told Adam, the Representative Kinzinger, that one of the theories that Donald Trump and Mark Meadows had and was pushing with the Department of Justice is that there were Italian satellites that were flipping votes from Trump to Biden using Italian satellites, just like the Venezuelan software, just like the Chinese bamboo-ridden ballots that were being stuffed into boxes, flipping votes. I mean, this is how, as Bill Barr said, it was like playing whack-a-mole with Donald Trump with all these crazy fraudulent theories, none of which held water, which is why Bill Barr took to the airwaves at one point and said, this was a full and fair election, and there was nothing, there was no fraud to overturn the outcome of the election. There's always fraud in an election. Sorry, there is. There's people that double vote. They vote the mother-in-law's ballot who died. They vote in the wrong precinct, but it doesn't overcome the electoral advantage of a president like Biden who won by 7 million votes or 10,000 in each
By the way, the incidents that we've seen have tended to come from Trump voters.
Republicans or Trump voters, right? They're like, get grandma's ballot. Here we go. Right. So but why are we hearing about this stuff now? Karen and I had a little bit of a disagreement on Wednesday. She thinks Jack Smith is completely leak proof. There's no way this is coming out of his office. And I disagree. We're getting strategic leaking, in my view, for a reason, because it's putting pressure on Donald Trump and his lawyers, an ever-changing cast of lawyers. Welcome John Lauro, fellow Florida bar member. Keep an eye on your bar license, my man, because, as one Trump lawyer recently said, it's a suicide mission to represent Donald Trump for all the reasons you and I, Ben, have outlined today and on prior podcasts. So that's sort of where we are. Yep. The indictment's coming. You and I don't get paid. It's a dime more by getting the date right. We've gotten it wrong more than we've gotten it right, but we got the range right. The question I have for you is, based on some photos of barricades going up in Fulton County, Georgia, who do you think's gonna? Which horse is coming in first, Fawneys or Jack Smith's second indictment?
I think they're going to happen within 48 hours or 72 hours of each other. So I don't know, but I would disagree with you. I don't think we've got it wrong more than we've got. I would say that I would put our batting average pretty high with these predictions. Maybe we don't get the exact date, but within a week
I mean that.
Two,
I just mean the trial date. I don't mean anything else. As I say on my profile for One Social Media Things, that I co-anchor the almost never wrong Legal AF.
I love it. But someone who is always wrong, Rudy Giuliani, admitting to engaging in defamation. We'll talk about why he did that in a federal court case brought against him by Georgia election workers. Trump had a second-year associate lawyer file what is like a kind of kamikaze legal mission before a federal judge in the Southern District of Florida, trying to reopen a case where Trump was already sanctioned almost $1 million for such a frivolous case. And Trump just lost a big CNN defamation case that he brought. We told you he was going to lose that case from the outset, and a Trump-appointed judge just ruled that Trump's defamation case is dismissed with prejudice. Let's talk about those final issues after this quick break.
Your pet's a member of the family. My Lily certainly is. Don't feed them like they're in the doghouse. Give them Nom Nom. Nom Nom delivers fresh dog food with every portion personalized to your dog's needs, so you can bring out their best. Nom Nom's made with real whole food you can see and recognize, without any additives or fillers that contribute to bloating and low energy. That's because Nom Nom uses the latest science and insights to make real good food for your dogs. Their nutrient-packed recipes are crafted by board-certified veterinary nutritionists, made fresh and shipped free to your door. Nom Nom's already delivered over 40 million meals to good dogs like yours, inspiring millions of clean bowls and tail wags. I love my dog so much and feel better giving her better nutrition. And my dog loves the food and other benefits they've seen. Plus, Nom Nom comes with a money-back guarantee. If your dog's tail isn't wagging within 30 days, Nom Nom will refund your first order. No fillers, no nonsense, just Nom Nom. Go right now for 50% off your no-risk 2-week trial at trynom.com/legalaf. Spelled try, NOM.com/legalaf for 50% off. Trynom.com/legalaf.
We're back live on Legal AF. Let's talk about this declaration that Rudy Giuliani filed in a federal defamation case brought against him by Georgia election workers Ruby Freeman and Shay Moss. We've talked a lot about this case on Legal AF. Giuliani and his co-conspirator Donald Trump made up these incredibly racist, misogynistic, disgusting attacks on these two Georgia election workers, basically compared them to drug traffickers, implied or outright stated that they have a history of committing crimes and that they are criminals and that they trafficked and harvested ballots the same way they harvest drugs. That was basically the statements that they were making. Some sick, disgusting, defamatory stuff. A lot of that was played at the January 6th committee hearing where they were both witnesses and some of the most compelling testimony there. They ended up filing a defamation lawsuit against OAN and Rudy Giuliani. OAN settled the case. Giuliani, we've talked about his failure to turn over documents and records and not participating, in discovery. And he was sanctioned over close to $80,000 for his discovery violations in the case. And then the judge basically said, hey, if you don't turn over these records, you're going to be held in contempt. And so I think Giuliani probably either assumed the records are worse than just stipulating to all of the actual evidence itself, or Giuliani destroyed the records. But either way, special counsel Jack Smith had a proffer session with Rudy Giuliani. So to be clear, special counsel Jack Smith has this knowledge. Special counsel Jack Smith knows one way or another. And one of the reasons that Giuliani may have agreed to file this declaration is if he already told special counsel Jack Smith these facts, they're going to come out anyway. And he doesn't want to undercut his proffer agreement with special counsel Jack Smith by lying in one forum and saying the other thing to special counsel Jack Smith. So whether it was just to stop the bleeding from discovery sanctions and potential contempt before the federal judge, or because he didn't want to harm his proffer agreement, or both, Giuliani submitted this declaration where he admits to liability. He admits he did it. So if you admit that you do it and you admit to all the allegations in the complaint, the plaintiff really doesn't need discovery anymore. You don't need the documents because you're the person's admitting to all of the claims, all of the charges, all the civil claims that are brought. And so that's what Giuliani did. So the case will basically become all about damages. How much should the jury award Ruby Freeman and Shay Moss? Because Giuliani's stipulating that he did everything that he is accused of doing in the complaint. Now, this is why on Legal AF, it's so critical that we show you the documents and we show you the evidence, because MAGA exists outside of evidence and outside of facts. So first, I want to show you what Rudy Giuliani said in this video that he made of himself that's promoted to the MAGA base. And then I want to show you the facts and the evidence. I want to do a comparison there. So here is the video that Giuliani made shortly after filing this document in court, where a court document is under penalty of perjury and has implications that are not attendant to making a video of yourself that's posted on Donald Trump's social media platform. Play this clip of Giuliani.
Number one, Giuliani is cooperating against Trump. Untrue. Giuliani is telling the truth, which is that Trump is entirely innocent. Fake news number two. Giuliani admitted that he lied. No. Giuliani, in a lawsuit, in order to reach the merits of the lawsuit, didn't contest the earlier portion of it with a clear statement that that was no admission that it was true or false. Happens all the time in lawsuits. It's called admission arguendo. And of course, only the most dishonest and cheapest of reporters deliberately misunderstand it. So let's make it clear. I have not admitted that I lied at any point. I haven't. And of course, I'm not cooperating against Donald Trump because there's nothing to cooperate about. The man is innocent and they're framing him.
Let me tell you something, Rudy Giuliani. I mean, what a weird video, number one. Number two, it's just simply not the case. Admission arguendo is not really a thing, okay? It's not a thing. And that doesn't happen all the time in litigation. Maybe in a personal injury lawsuit where someone gets into like a car accident and there is admitted liability because there's tape of somebody getting into the car accident. So it makes no sense to fight the liability portion. It's just going to piss off the jury. So you just go to damages. In that situation, maybe you have a stipulation of liability and you just talk about damages. In a defamation case, it's essentially unheard of to admit to the defamatory statements. That doesn't happen ever. But let's take a look at Rudy Giuliani's declaration that he filed, and let's test what he just said based on what he actually said in court. Because when you look at it, it says, if you go to number one, it says, defendant Giuliani concedes solely for the purposes of this litigation before the court and on appeal that defendant Giuliani made the statements of and concerning plaintiffs, which include all of the statements detailed in plaintiff's amended complaint. And he does not dispute for purposes of this litigation that the statements carry meaning that is defamatory per se. So all of the allegations that are alleged in the complaint by Ruby Freeman and Shay Moss here, Giuliani says, yes, they carry with it a defamatory meaning. Two, defendant Giuliani, for purposes of this litigation only, published those statements to third parties. He transmitted it to third parties. That's another element of a defamation claim. Three, defendant Giuliani, for purposes of this litigation only, does not contest that to the extent the statements were statements of facts and otherwise actionable, that such actionable statements were false. He does not contest that the statements that he made were false. In other words, the statements that he made were false. And then number four talks about him stipulating to liability on all of the other claims like intentional infliction of emotional distress. So it's in the declaration. It's right there. You filed it. And that's where, Michael Popok, it's not a Democrat thing or a Republican thing. And this is where the media gets it all wrong. It's just a fact thing. This is what you said. And how offensive it is. It truly offends me to the core when these MAGA Republicans just lie like that, viciously gaslight. Because what they're saying to you, they're saying you're stupid and I'm going to take advantage of you. F you, screw you. That's what they are saying. That's why we got to do the show to show the facts. I know I took a lot of that topic.
Right. I got two things I want to say. I got two things I want to say in response. Well, one of them is you asked the question in the beginning, why would he do this? And I'll give my answer. Why would he enter into a stipulation on many aspects of liability, but not all? I won't talk about that in a minute. He left himself some defenses, even on liability side, and then he'll fight on damages. So on the, why would he do that? Because if he doesn't have the documents that support his case, either because he's lost them, hasn't retained them, what the judge could do and what he was staring down the barrel of with Beryl Howell, the former chief judge of the DC Circuit Court, who was basically fed up with Rudy Giuliani and his lawyers and was getting increasingly more upset. And when you make a federal judge upset, you end up getting more sanctions, more fines, and they start to escalate. right? They start to build on one another, and eventually you get to contempt and dispositive sanctions like default judgments against you. He was awful darn close to having a default judgment on liability, retaining no defenses whatsoever. So he sort of kind of cut it in half and said, I'll give you a stipulation. I'm going to reserve a couple of defenses on liability, which I'll talk about for 1 second, and then we'll go fight over damages. And the lawyers said, we can either keep litigating this and see what the judge does, or we can take the step and basically we're not afraid of any of his defenses and we'll go right to money damage. How much damage did these two poor election workers suffer at the hands of being mercilessly attacked, defamed, maligned, with malice? Doesn't have to be actual malice, just malice and ill will, punitive damages included, including them being doxxed, including them having to move out of their house and all of that. How much is that worth? The couple of defenses he reserved for himself, and what I assume he thinks was a good deal to cut, versus getting a sanction against him of a liability found by the federal judge in a sanction, is he kept a statute of limitation, and he kept the argument that some of his statements were constitutionally protected. And the plaintiff's team was probably like, okay, you're not going to win those. You want to still litigate over that? Okay, we'll take all the other stipulations where you admit to every paragraph of our complaint that what we said was true. The most concerning thing about that clip you played, Ben, though, is what it's going to do to Jack Smith's team, who he's met with twice, Giuliani, in 2 separate meetings, and we've been told has been trying to angle himself for a more fulsome immunity deal. He only got a queen for the day immunity, which is you tell us the truth right now and don't lie. And we won't prosecute you based on your words this day. If we get the information independently, it's a different story. If I'm the team, I'm going, to paraphrase you earlier, fuck you, Giuliani, with your continued defense of Donald Trump. You want to continue to do that? You can do that with your name on the other side of the V in an indictment. And I think that does not help him. And it just shows you how in another world, a MAGA universe, that he is orbiting. Because you would never allow your client, Ben, or you'd leave the case if your client just did what he did while you were trying to negotiate behind the scenes for an immunity deal.
Couldn't agree more with you. And it's because they operate in this made up world where they don't hold hearings in official places. They don't submit official electoral certificates, right? They go to the, whatever, the Four Seasons construction yard or whatever that was, right? Like next to the adult film shop. And that's where they
landscaping and gravel.
Four Seasons landscaping. That's where they hold it. They do hearings in hotel lobbies and they pretend they're actual hearing. They're not they're not for law and order. So the projection and confession that they always do is that when they say that Democrats are not for law and order, Democrats are going through the court system, through a jury system. Democrats are existing in a system where evidence matters. And that shouldn't be unique to Democrats. Like that should just be, okay, what's the evidence? If you say that there are 17 audio recordings of President Biden engaging in bribes, if you make that, show me the audio. Bring it, because that would concern me. Yeah. I don't care if I'm a Democrat, independent, not if that's real, show it to me. But when that turns out to be a lie, or that a whistleblower is actually not an unregistered agent of China, or another whistleblower doesn't exist, or the documents don't exist, or the Russian oligarch you're relying on, one, it's a Russian oligarch to begin with, but two is saying, I didn't say that. That's not an accurate representation. And then you go, well, that's sufficient basis for impeachment inquiry. It's like, what are you talking about? What are you talking about?
And that compare and contrast that you do so well in your hot takes between Biden and Trump, look at the compare and contrast here. Biden's let it be known through his press secretary that he is not going to pardon Hunter Biden, regardless of however those chips play out. Further investigations be damned. And compare that to Donald Trump, who's going to pardon everybody, including himself, if he gets back into office.
Yeah, I interviewed Democratic Congress member Raja Krishnamurthy, and I asked him, I said, look, because he's a Harvard law guy. I said, imagine if you as a licensed lawyer made up to a court that you had audio recordings that didn't exist, you'd lose your license. It's unfathomable. Yet you have Jim Jordan, who's not a licensed lawyer, leading the Judiciary Committee doing just that. You have James Comer, MAGA Republican, leading the House Oversight Committee, who's doing just that. It is offensive and despicable. All right, back on track, though, to other things that are offensive and despicable. I want to talk just about these two real frivolous cases, one that just got dismissed, another one that was dismissed months ago when Trump was sanctioned. But it just goes to show you, Popok, like how desperate, how vexatious, how frivolous these cases are that Donald Trump is bringing. Everyone remembers now that case that Donald Trump and his lawyer Alina Habba filed against Hillary Clinton over a year ago, alleging that there was a massive conspiracy. They sued her and 30 other individuals, saying that they're to blame for the Russia investigation, which, by the way, is a valid investigation where many people were actually convicted, including people closest to Donald Trump who are very high up, who he later pardoned. But he said that somehow constitutes a RICO or racketeering case and defamation. And the court's like, it was filed in federal court. Judge Middlebrooks was like, what are you talking about here? Like, the statute of limitations, you've blown. These aren't real allegations. You're just saying the word RICO. And like he said, every allegation is false. Everything you're saying is wrong here. Dismissed the case, gave Donald Trump the hint on the first complaint that was filed that he was going to sanction him, but Trump filed an amended complaint with Habba. And it's one of the most powerful sanctions orders by Judge Middlebrooks I've seen. Here, pull up the order by Judge Middlebrooks here, where Judge Middlebrooks basically says, essentially, every allegation was wrong. He goes, this case should never have been brought. Its inadequacy as a legal claim was evident from the start. No reasonable lawyer would have filed it, intended for a political purpose. None of the counts of the amended complaint stated a cognizable legal claim. 31 individuals and entities were needlessly harmed in order to dishonestly advance a political narrative. A continuing pattern of misuse of the courts by Mr. Trump and his lawyers undermines the rule of law, portrays judges as partisans, and diverts resources from those who have suffered actual legal harm. And then there was another part of that sanctions order where he basically recommends disciplinary proceedings for Alina Habba. He goes, so who's responsible for this case and others like it? The rule of law is undermined by a toxic combination of political fundraising, with legal fees paid by political action committees, reckless and factually untrue statements by lawyers at rallies and in the media, and efforts to advance a political narrative through lawsuits without factual basis or any cognizable legal theory. Lawyers are enabling this behavior, and I am pessimistic that Rule 11 alone can effectively stem this abuse. Aspects may be beyond the purview of the judiciary, requiring attention of the bar and disciplinary authorities. Additional sanctions may be appropriate, but legal filings like those at issue here should be sanctioned under Rule 11, both to penalize this conduct and deter similar conduct by these lawyers and other lawyers. So that doesn't stop that. You thought it would end there, right? $1 million or close to $1 million in sanctions. The case is dismissed. But out of nowhere, there's a new filing on this docket. And I'm like, who's filing on this docket? And it's called Plaintiff's Motion for Indicative Ruling Based Upon New Evidence. And I'm like, who's this guy? Jared Roberts? I never heard of this guy before. And then I looked him up. Jared Roberts. There he is. Jared Roberts hasn't even been a lawyer for 2 years yet. His experience is basically internships. And then he joined, this law firm, and he's now practicing political and constitutional law. And he's the one who filed it. And if you actually go into this filing as well, one of the things he says is he calls out the judge in footnote 1 for being for being biased and says that like we're gonna demand your disqualification. This second-year lawyer is calling out federal judge Don Middlebrooks, and he's an idiot, the second-year lawyer, because they already tried a disqualification motion. Alina Habba filed a disqualification motion against Middlebrooks. This was before anybody knew who Judge Eileen Cannon even was, because it was before the August 2022 search warrant issues. And months before that, I think it was actually in May of 2022, in the disqualification order, Middlebrooks is like, you're trying to disqualify me so you can get in front of Judge Eileen Cannon. That's what he says that in the order, and called him out. So a disqualification motion was already brought, was already denied. And what now this second-year associate is trying to claim is that the Durham Report, where no recommendations were actually made in the Durham Report, the only actual criticism from Durham when you get through all the kind of BS, he says Durham says, and this is the Bill Barr appointed prosecutor, that the FBI should have first opened an initial inquiry before opening the full inquiry. That's what they said, but didn't recommend any recommendations. And then Durham was 0 for 2 in his prosecutions against the people he prosecuted. 0 for 2. To put that in perspective, Merrick Garland has prosecuted nearly 1,000 January 6th insurrectionists and has never lost a single jury trial. Never lost a single jury trial. What perfect record. Like 1,000 for 1,000, basically, when it comes to whatever it is in jury trials. Compare that to Durham, 0 for 2. So they're saying the Durham Report means that they should reopen this case, and they filed it in front of Middlebrooks. Popok, I think another Rule 11 sanctions motion is going to be brought. There's 30 people who now have to file a motion. I think they're going to bring a Rule 11 against this guy. Yeah. I think the judge is going to sanction the second-year associate and the law firm for even bringing this thing, for making people respond. Touch on that, and then bring us out with what happened in the CNN defamation case.
Yeah. Poor Jared. Here's my artist rendering of what happened. He's the only Florida bar member in the Virginia law firm that's now representing Donald Trump, this Benelli law firm. We saw this guy before, actually, Ben. You've just blotted it out of your memory because he filed something a while ago in the appeal. Now, the Durham Report came out in May. By my calendar, it's almost August. So they waited from May till August to claim new evidence because they were somehow vindicated by the Durham Report. And in the May, June, and July period, which is more than enough time, no senior lawyer or partner in their law firm thought it was worthwhile to move for special admission so they could practice law in front of this court that they just attacked the judge on once again. So they called up Jared on the intercom. Jared, come down here. Okay, can you just read this and sign it, please? We have to file it today. Well, what does it say? Okay, let me tell you how ludicrous this is. First of all, they want the judge to take judicial notice of the Durham Report that has no conclusion and no recommendations whatsoever because, I don't know, it's on some fancy paper that says special counsel. I mean, that's not the grounds for recognizing something with judicial notice so that you don't have to have it presented into court. That's one. Secondly, I'm just going to show but one example, and I'm sure every one of our part of our audience is going to know what the problem is. And this is the best example, I think, that's in the Durham, that's in the new filing, in which they're telling the judge, you were wrong, you shouldn't have dismissed the case, you shouldn't have sanctioned us, and your findings, judge, that things were just incredible and absurd and not to be believed. You're wrong, judge. And let me give you an example. This is from their brief. Quote, to begin with, this court called it implausible and categorically absurd that defendant Comey, that's James Comey, the FBI director, would have conspired with defendant Clinton, that's Hillary Clinton, to harm President Trump. Stop right there. James Comey, who blew the election for Hillary Clinton because he announced he was looking into her emails a week or two before the election, their theory was he was conspiring with Hillary Clinton in order to throw the election in favor of Hillary, who lost the election. Okay, let's go on. They say the Durham Report, however, found that at least some high-level actors not leadership, not Comey, actors within the FBI, unnamed. Central to the Crossfire hurricane investigation, that's Russia collusion, had a, quote, clear predisposition against President Trump, which was not shared in their investigation or lack of investigation of Clinton. Durham Report at 47. How does that, even if that is a lift from the Durham Report, how does that prove that the judge was wrong, that it was implausible and categorically absurd that Comey conspired with Hillary Clinton? A couple of FBI guys didn't like Donald Trump? Okay, that is like one of their best examples in their brief. This judge is going to deny this within the next week or two. We'll do a hot take and or a show on it. There's going to be a motion for sanctions that he will invite. And this poor kid is going to get, well, I don't feel sorry for him. He signed it. He's a Florida bar member, just like me. He took an oath to be an officer of the court and not mislead the court. While separately parallel, there's an appeal going on at the 11th Circuit. They had to post a $1.3 million cash bond. They love posting those cash bonds against the sanctions order. And so that's going on. But no, they don't want to wait for the 11th Circuit. They want to use the Durham Report as a press release, so they shove it back to Middlebrooks. So that's where we are with that. We can stay in the Southern District of Florida with a whole nother judge that was handling a case that you and I touched on several months ago, but sort of, let's be frank, all the indictment fever sucked the air out of the room, and we didn't really continue to follow it. And there weren't any really new developments other than Donald Trump sued CNN for $700 million because he doesn't like the fact.
475, but who's
all right? What's a few $100 million between friends, Ben? It's 475 million, claiming that because they compared him to Adolf Hitler and how he abuses the media and some other things, I've been defamed. And the federal judge in the Southern District of New York, who's a Trump Federalist Society judge. There's not many of them in the Southern District of Florida, but there is one. I never appeared in front of him. He was a longtime state court judge in Fort Lauderdale who got appointed by Governor Scott, and he got elevated to the feds by Trump. They actually talked about him being, because he's also Indian American, he would kind of fill a need there, a niche for the Florida Supreme Court. He didn't get that job, but he got the job of federal judge. And even though he did it noisily, took some pot shots at CNN, Ben, maybe you like talking about those things. He then ruled against Donald Trump, didn't only dismiss the complaint for defamation at the pleading stage, meaning no discovery, no depositions, no evidence, no trial, right now just on the pieces of paper, but he dismissed it with prejudice, meaning I'm not even going to give you the opportunity to amend because the facts are clear. This is the clip. This is the statement. It's either actionable in defamation at law or it is not, or it's protected or privileged, and I don't even want to see you in my courtroom again. Now Donald Trump's going to have to try to appeal that to the 11th Circuit. But I know you took issue, and rightly so, with some comments that this particular judge made in his ruling. You want to talk about those?
So Trump basically was alleging that when CNN referred to what Trump did as the big lie, referring to it as the big lie implied the big lie that Hitler told. And the judge said, well, that's an opinion and that's not defamatory. But what the judge said about that, was CNN's statements, while repugnant, this is at the very end of the ruling, when the motion to dismiss is granted, CNN statements, while repugnant, were not as a matter of law defamatory. The case will therefore be dismissed with prejudice. Accordingly, it is hereby ordered that it's dismissed with prejudice. Okay. What's repugnant about that? Like, Trump tried to overthrow our democracy, and he consistently lied. There's nothing repugnant about that, but the judge did the right thing in dismissing the case. But you see how, these jurists who call themselves, I'm a conservative jurist, I mean, it is so repugnant for a media entity. There's a lot of repugnant things that CNN's done lately. This is not one of the repugnant things that they've done. It is so repugnant for them to refer to January 6th as insurrection. How such a repugnant thing to call out Donald Trump trying to overthrow our democracy. I mean,
what would that judge What would that judge say about, we could spend an entire show, which we're not going to, all the things Donald Trump said about prosecutors and their families. Jack Smith's a crackhead. Jack Smith is a closet Jew. And everything else, that's not repugnant.
Yeah, and just so people know, when Donald Trump does that, it's when he says Jack Smith, if that's even really his real name. That's the implication that Donald Trump is making. That Jack Smith changed his name. But yeah, no, and that's the thing. I mean, let's just face it. That's not a conservative position to call out someone who's calling out an insurrection and saying that that's repugnant. I'm sorry, it just isn't. And what we have to do is both a short-term and long-term, right? There's short-term goal of reacting to what's happening and providing the accurate news because there's such a swarm of disinformation out there. But the long-term process here has to be a generational task that we're all committed to. Because you mentioned the Federalist Society, what these MAGA Republicans did even before they were MAGA, starting in the 70s, was building the media infrastructure, the judicial infrastructure, the state and local infrastructure that completely caught everybody off guard, but they were building it, and you could see it as they were building it. And then MAGA kind of took it over, used the trappings that they created to frankly entrap our democracy. And we have to now reverse that trend by now making sure we build the infrastructure for pro-democracy, for truth, for evidence-based approach. And that's what needs to prevail. And so that's what we're committed to doing here on the MeidasTouch Network. Yes, short-term objectives, building what we're doing brick by brick, responding to the breaking and daily news, but generationally making sure that in the future, there ain't people saying that, oh, it's so repugnant that you would criticize what happens on January 6th. No. Anyone who participated in the January 6th insurrection is a traitor, is a criminal, committed treason. And we shouldn't have to mince words when looking at that and saying and calling it out for what it is. Popok, we've got new Legal AF merch to talk about. We've spent a long time making this merch. Karen Friedman Agnifilo specifically was involved in the design process. You were heavily involved in the design process as well, but a lot of time was spent on this. So make sure you check out store.MeidasTouch.com. That stuff looks good.
By the way, that's a famous logo designer who volunteered because he believes in democracy too.
Oh, yeah, no, a lot of time, a lot of attention here. Go to store.MeidasTouch.com. Get your Legal AF gear right now. Gear up with all of the MeidasTouch gear. 100% union made, 100% made in the USA. Store.MeidasTouch.com. Definitely check that out right now. Also, make sure you're subscribed to our YouTube channel. YouTube watchers, make sure you are subscribed to the audio of Legal AF. It really goes a long way to help. So if you watch this on YouTube, please just do me that favor. Search Legal AF wherever audio podcasts are available. Hit subscribe. I want to make sure people are subscribed on both platforms. That really helps the show. It helps with everything that we do here as well. Thank you for everybody also who's become members of the YouTube channel. You unlocked the Karen Friedman Agnifilo emoji last week. We're going to be building towards an emoji of me, apparently, that we're going to be releasing. I think in this next week, I told Jordy if we got 300 memberships, new memberships, we would do an emoji of me. So that's one of the ways you could contribute to this network and help it grow by becoming a member and getting you could gift memberships to other people as well if you're already a member. But the best thing you can do, share these videos, let friends, family, coworkers, colleagues, neighbors, let them know about this network. Right, we've got less than 470 days now, I think, until the general election. So every day matters. So make sure you're registering voters or making sure people are registered in your family. Don't wait until 2024 comes. Focus on registering voters for voters. Do whatever you can do in your community and share these videos, share this network, share Legal AF with anybody that you know. That goes a long way to help. Thank you, everybody, for watching this episode of Legal AF. Legal AFers, thank you. This community, seeing everybody in the chat, I'm starting to recognize all the people in the chat now too, and seeing everybody continuing to come here. Thank you. This community is such an honor for me and Michael Popok and Karen Friedman-Agnifilo and all the other commentators at this network to be a part of this community with you. So thank you for all of the work that you do. We'll see you next time on Legal AF. I'm sure it'll be a historic and exciting one. Shout out to the Meidas Mighty.